Super Talk 99.7 WTN. Jack Johnson's with us. He is Senate Majority Leader in studio, responding to this tragic event that resulted in the death of Jillian Ludwig, a Belmont University student, believed to be at the hands of the alleged shooters, a man by the name of Shaquille Taylor, who was out of jail. He had multiple offenses against him on his record. The ones that we are focused on he was released from jail in April because of an inability to stand trial, according to a 3-doctor panel. Jack, are you familiar with how all of that works with regard to, and I know that this is weedy. I mean, it is as in the weeds as you can get, but I think it's very important that people understand how these things are determined. And I think there's a little confusion about they're independent of one another. There's one determination as to whether or not someone is competent to stand criminal trial, and there's another determination that is made as to whether or not someone is a danger to themselves or to other people, so much so that they need to be involuntarily incarcerated. Do I have that about right?
Yeah, I think that's a great assessment of it. And the frustrating thing is when you look at someone like this particular individual who has been charged, took a plea deal, I suppose, because he was on parole, and then he violated his parole, and he went to jail for a year. And it begs the question, how did that legal process take place, and yet he commit another crime or is charged with another crime and then be released? And so these are all, again, I think very, very fair questions. And the ultimate question is, if someone is deemed to be incompetent to stand trial and they are known to have violent tendencies, they have committed violent acts. To me, I think as a layperson, and I'm not an attorney, but these are the conversations we're having with our judges and our prosecutors, law enforcement, and so forth, is why does that not rise to the level of warranting involuntary confinement? And again, I respect that we need to be careful about involuntarily committing people. But for an individual like this who has been deemed to be incompetent to stand trial and we know has a violent history, it is inconceivable, I think, to a reasonable person that he just be released back out onto the streets. So what, if anything, do you expect will come out of this from the General Assembly's standpoint? So we're going to look at the process, and I also want your listeners to know that there have been other instances like this where an individual was determined to be incompetent to stand trial and yet had a violent history. They did the mental health evaluation, and even some stakeholders determined that this individual needed to be released, and yet the court insisted and in fact ordered committal, involuntary committal of the individual. So why is that happening in some jurisdictions and not others? Because that tells me that there are judges out there who interpret existing statute as giving you the levers of power, the tools necessary to be able to remove that person from society. And so I think we need to, it's our job as policymakers in the General Assembly to make sure that our judges, our DAs, law enforcement, mental health professionals have the tools they need in order to get these violent people off the streets. And that's what we're working towards, and I think we will have legislation to accomplish that when we reconvene in January. And
is it oversimplifying the situation to say that if someone is charged with violent, felonious acts and they are deemed to be incompetent to stand trial against those charges, that should trigger some mechanism by which they at least are automatically put through the process of determining whether or not they have the ability to be out amongst the general public? One would think that one would go hand in hand with the other. If you could not understand the difference between right and wrong and the charges against you, then necessarily you would not, it would be unsafe for you to be in the general public.
Exactly. And ultimately, in terms of these committals, and for an individual who has been being involuntarily committed, oftentimes it is for further evaluation, right? They go in, they do an initial assessment of the individual, and multiple doctors analyze and assess the particular individual. They make that determination. And look, there could be instances where someone is deemed to be incompetent to stand trial, but they didn't commit a violent act. Maybe they were, shoplifting or some other non-violent type of crime, and it's a different scenario. But when you have an individual like this particular person who not only was deemed to be incompetent to stand trial, had a long violent criminal history, it is unacceptable that there are not the tools there for the judges, prosecutor, whoever to insist on this individual being involuntarily committed. And if a court is unwilling to do that, then there should be an appeal that goes to the Court of Appeals.
Under existing law, though, I mean, am I looking at the district attorney in this situation for not following up and asking for the appellate process to move forward? I mean, frankly, Jack, in the spirit of looking for justice for this family, I'm looking for who to blame. And that kind of circles back to the question I originally asked Cameron Sexton, the Speaker of the House. And you obviously disagree with this, but he pointed at least partial blame to the Tennessee Senate in the special session. So I would ask you, is there a legitimate loophole in your assessment of this situation, or is it a combination of the district attorney not following up and doing the necessary paperwork to try to make sure that this guy gets kept off the street? Because we're told, I think the Tennessee Star did some good reporting on this, we're told that there are well in excess of 200 individuals in a similar situation in Davidson County right now. Right, yeah, that are out on the streets when they should have. I think a strong case could be made that they should be involuntarily committed. I want to be hesitant in terms of trying to blame a particular individual or a particular part of the process. What I want to make sure is that we, as members of the General Assembly, are looking at the policies that are on the books for instances like this, so that a DA, in the interest of justice and in the interest of protecting society from someone who is violent, can make that case for involuntary committal. And if the court disagrees, that happens all the time, that there is an appellate process that can be utilized. That's the type of policy that we need to be looking at. At the end of the day, there's one person to blame for this particular incident, and it's the individual who shot the weapon, and a stray bullet that struck that beautiful 18-year-old girl. But as a result of that, and this all stems from our earlier conversations going back to March and April and through the special session about public safety. And these are good conversations to have, and because we know that so many of the people who are committing these crimes are otherwise mentally incapacitated or suffering from mental illness or drug and alcohol abuse. And when they are violent and they are a threat to society, they need to be removed, whether that's incarceration through a traditional jail or whether it's through a mental health treatment facility. Senator Jack Johnson, Senate Majority Leader, with us for the better part of 30 minutes or so. Just to circle back, as I did with your colleague over in the House of Representatives last week, I want to circle back and just kind of reiterate for those just joining us. I understand he has his thoughts on where legislation was and where it wasn't. You were unaware of any legislation before that got voted on in the House or before the Senate that would have in any way prevented Shaquille Taylor from being released from jail.
I'm aware of no amendatory language, no bill language, or anything else that had been filed or introduced into the system. Now, perhaps there were discussions about crafting an amendment that might go on a future piece of legislation, but I'm not aware of any language that had been drafted and filed in the system. And it's all the more reason, and I hate to bang on this drum, but it's so important for your listeners to understand the Senate position relative to that special session. That when we have a special session, we should go in for a specific purpose, know what that is in advance, and we go in, we debate it, and we do whatever we're going to do. We pass the legislation, we don't pass the legislation, and we go home. We do not need to be rushing legislation that is very complex, has multiple stakeholders, district attorneys, law enforcement, judges. To my knowledge, none of them had weighed in on any of this proposed language that was going to be considered in the matter of 12 to 24 hours in a special session. That's not a good way to run government, and I'm very proud of the Senate, the Tennessee State Senate, and for the way we conducted ourselves in the special session, and I look forward to regular session when we reconvene in January and having more prolonged conversations about these very complex matters.
I don't want to put words in your mouth, but it sounds like you stand by the Senate's position during the special session that you were there specific to the call of the governor and for no other purpose.
I absolutely do. I think we need to be very careful about going into a special session with notice requirements suspended and ramming legislation through. Might I remind you that there were over 105 bills filed by the House of Representatives, and many of them had Senate companions, full disclosure. But to be considered in a 4 to 5 day special session. That's not the way to govern a state. We can have these conversations while we're out of session, and when we reconvene in January, we can take up some of these very complex matters.
Jack, thank you for being on with us.
Thanks,
I appreciate
Matt.
you, and we appreciate everything that you do for Williamson County and the state of Tennessee.
Thanks, sir.